Thank you. Good morning, Chair Esquivel, members of the board. I'm Sam Bivens with the Administrative Hearings Office, and as you mentioned, I'm here to talk about the proposed order in the Marble Mountain Ranch enforcement proceeding. I'm going to talk briefly about how we got here, how this case came to the AHO, the procedural history, our key findings of fact and conclusions of law in the proposed order itself, and then address the comments we've received to date on the proposed order. So first of all, this is an enforcement proceeding that was heard in November 2017 by then board member Moore. It was assigned to the AHO in December 2021 for further proceedings, including but not limited to preparation of a proposed order. In 2023, the parties informed the AHO that there was no need for further hearings or evidence to address changes in conditions since the 2017 hearing. And so we proceeded to prepare the proposed order that's before you today. Under Water Code Section 1114, there are 4 options that you have in dealing with the proposed order that's before you today. One is to adopt it in its entirety, including the change sheet, which is the course of action that we're recommending today. You also have the option to make technical or other minor non-material changes and adopt the proposed order. You can reject and remand the proposed order to us for further proceedings to either develop additional evidence or make more material changes to the proposed order. And then finally, you have the option of simply rejecting the proposed order and developing a new order based solely on evidence that's already in the record. And again, we're recommending that the proposed order be adopted, including the change sheet that was provided last week. Next slide, please. So Marble Mountain Ranch is a guest ranch in Siskiyou County near Soma's Bar. Seems like a very, very nice place if you like outdoor activities and horseback riding and such. It's operated by Douglas and Heidi Cole. And the Coles claim a pre-1914 water right to divert up to 3 CFS and approximately 2,000 acre-feet a year from Stanshaw Creek, which is a tributary to the Klamath River. They use that water for domestic purposes, for irrigation, for hydropower generation, and occasionally for firefighting uses. And I want to make clear that the validity and quantitative scope of the Coles claimed pre-14 right was not at issue in this hearing. We're only talking about whether their use of water is reasonable, whether their method of diversion is reasonable, et cetera. But we're not concerned with either the validity or the scope of that pre-14 right in terms of quantity. So Stanshaw Creek itself, as I mentioned, is a tributary to the Klamath River, and it provides some pretty important habitat functions for listed coho salmon in that watershed. I believe it's the Southern Oregon and Northern California coastal evolutionarily significant unit of coho salmon. And principally what Stanshaw Creek does is provide a thermal refuge for salmon when temperatures get high in the Klamath River. Stanshaw Creek generally, as it connects to the Klamath River, there's a cold water pool that's formed at that connection in all but the driest of conditions. And migrating and juvenile salmon can use that cold water pool to sort of escape the high temperatures that occur in the Klamath River, particularly during the summer months. I'm going to spend a little bit of time talking about the sort of geography and the diversion infrastructure. So if we could have the next slide, please, which has a couple of maps and schematics on it. So the Coles point of diversion on Stanshaw Creek, the actual point of diversion diverts water via a rock dam. There's no real diversion control structure on that dam. The only way to modify the amount of water diverted at the point of diversion is to adjust the stacking of the rocks of the rock dam, and that can be done, as frequently on a daily basis, but not more than a daily basis. If you look at the schematic on the right hand side of the slide, you can see that the The water diverted at the point of diversion on Stanshaw Creek funnels through by gravity through an earthen diversion ditch down to a point of bifurcation. And at the point of bifurcation, the water can go in two directions. It can either go through a 2-inch pipe to a water treatment facility and potable water tanks where the water can be put to domestic use, or it can go to a penstock and into a hydroelectric plant. The tailwater from those hydropower operations can either then be put to some irrigation use, or it goes into a pond at the end of the system. When the pond overflows, that hydropower tailwater is then discharged into Irving Creek, which is another tributary of the Klamath system. I want to focus a little bit on the nature of the hydropower diversions. That was probably the most central issue of the enforcement hearing. The hydropower system is pretty old. It operates using an 18-inch Pelton wheel that needs approximately 2 CFS of water to function. And so you have a kind of a twofold problem here that's related to the lack of a diversion control. One is that water can be diverted into the system that's more than needed for consumptive uses like domestic use and irrigation, but less than is needed to drive the Pelton wheel. And so that water is generally not, that excess water is generally not put to beneficial use. On the flip side, when flows are quite high, that earthen diversion ditch can overtop and slough and have some water quality impacts that were the subject of a regional board, I believe it was Region 1, or maybe it was Region 5, cleanup and accountability order. And again, not only is there that overtopping and sloughing problem with the ditch, but you've got more water coming into the hydropower system than the Pelton wheel can use to generate hydropower. And so again, you have a problem with water not being put to beneficial use. The case was initiated after some complaints in, I believe, 2015 or 2016 about alleging that Marble Mountain Ranch's operations were in some cases dewatering Stanshaw Creek entirely and causing harm to public trust resources. So the prosecution teams, I'll call it a charging document, made, I'll say, 4 critical allegations of unreasonableness. One is the lack of a diversion control. 2 is that the hydropower operations were generally unreasonable, both because of the beneficial use problem I mentioned. The ditch, they alleged issues with the earthen ditch, both from a water quality overtopping perspective and also an allegation that the conveyance losses through that ditch were unreasonable, and that all of these issues caused harm to public trust resources in Stanshaw Creek and the Klamath watershed, principally to endangered coho salmon. One other point to mention, if you look at the map on the left side of the slide, you can see Stanshaw Creek comes down from the right down towards the bottom left. You can see the point of diversion up there at the top right part of the screen, and then there's a marking for the State Highway 96 culvert, which is an important location because that culvert is essentially impassable to fish. So the area of habitat value that we're really talking about, the various experts referred to it as the anadromous reach. It's the reach between the Klamath River, which isn't noted on the map, and that Highway 96 culvert. I think it's less than a mile of stream. And with that, let's move to the next slide. All right, so this, as I mentioned, case came before then Board Member Moore in November of 2017 with 2 hearing issues. They were a little bit longer than this, but I'll reduce them to their essence. One is the past or current diversion or use of water from Stanshaw Creek in Siskiyou County unreasonable, and 2, if the diversions were unreasonable, what corrective action should be implemented. And we had a number of parties participate in these hearings. Of course, the prosecution team and respondents, Marble Mountain Ranch and Douglas and Heidi Cole, and then also the Karuk tribe, the National Marine Fisheries Service, California Department of Fish and Wildlife, Old Man River Trust, Conrad Fisher, CSPA, and Klamath Riverkeeper. Next slide, please. So I'm going to provide an overview of the key findings as set forth in this proposed order. And the first one, I think, is pretty basic. It's that the State Water Board can, of course, consider impacts to public trust resources in assessing the reasonableness of use or the reasonableness of a method of diversion. It turns out that this order, if adopted, will be the first order to make that finding explicit, but I don't think it should come as any surprise based on the general contours of both unreasonable use doctrine and the public trust doctrine. Two, the evidence in the record suggests that Marble Mountain Ranch's consumptive uses are generally not unreasonable. And actually, let me pause there. I want to make something clear, which is when we find on an issue that the prosecution team, when we suggest that the prosecution team hasn't met its burden on a particular issue, that doesn't mean that you're affirmatively finding that that a use is reasonable. It's at most a finding that the use is not unreasonable based on the evidence in the record. That's a fine distinction, but I want to make clear that adopting this proposed order and the findings therein, you're not necessarily endorsing any particular type of use or method of use. It's strictly an issue of evidentiary burden. So I wanted to make that clear. The hydropower operations, the proposed order finds that they're unreasonable for a couple of reasons. One, that water is frequently diverted but not put to beneficial use for the reasons I described a little earlier in this presentation. And two, that in this system at least, and in this particular set of factual circumstances, the discharges to Irving Creek, rather than returning the hydropower tailwater to Stanshaw Creek, are also not reasonable. That's not a general finding that water from one stream cannot ever be discharged into any other. And the order makes that clear. We're very much limited to the facts of this case here. So the order's directives don't forbid hydropower diversions outright, but they do require that water that's not used by the Coles and Marble Mountain Ranch consumptively be returned to Stanshaw Creek. The proposed order also finds that a diversion control device is needed to ensure that all water that's being diverted is put to beneficial use, and that will also help avoid the overtopping and the water quality impacts from excess diversions that were the subject of the regional board proceeding in order. So, I guess the upshot here is that, we would expect with the implementation of this order that you'd see quite a bit more water in Stanshaw Creek than there has been historically. There are a couple of, say, larger issues on which the proposed order finds that the prosecution team and the other parties did not meet their burden of proof and persuasion. One is on the bypass flow issues. So the National Marine Fisheries Service recommended a 90% bypass flow and a 2.0 CFS minimum bypass in the anadromous reach. There were, I think, two significant problems with that. One is a rule of priority problem. There is at least one, possibly two, junior diverters on this system who were not a part of this proceeding. And under the rule of priority in California, before you cut off, and this is general, but before you cut off senior diverters, the other more junior diverters need to be reduce their diversions entirely. Unfortunately, those other parties' diversions were not at issue in this proceeding. We can't, develop a global order for the system based on this record. So, as the proposed order lays out, wouldn't be appropriate to impose a bypass flow in this particular procedural context. And the other issue is the amount of evidence and the nature of the evidence supporting the 90% bypass flow recommendation. The 90% flow rate in particular was based almost, at least based on the evidence, entirely on a sort of general presumption in an academic paper by a gentleman named Richter, that the loss of cold water is the loss of water is generally bad for the system, and 90% is designed to ensure a quote high level of protection for the system. And there just simply needs to be more evidence and information there in order to bridge the analytical gap between the ultimate bypass flow recommendation and what's actually going on in the system. And I want to highlight footnote 17 of this order, which talks about the kind of information that's ultimately needed to bridge that gap. It doesn't necessarily require comprehensive site-specific studies, but it does require something more than reliance on a presumption for what would be, I think, a uniquely high bypass flow requirement in the state of California. And then on conveyance losses, I won't spend a lot of time talking about conveyance losses, but the evidence suggests that what's observed in terms of conveyance losses is not atypical for the area. And there's a fairly detailed discussion, including some responses to comments received prior to this board meeting on pages 27 through 30 of the order. The next slide, please. So I want to go through some of the comments received, and we received a number of, I had to prepare this PowerPoint before all the comments came in, so I want to highlight some of the other comments as well before we kind of get into the meat of things. First, we received a number of technical and stylistic comments from Alan Lilly, our former presiding officer at the AHO. Many of those are incorporated in the chain sheet that's before you, and we thank Mr. Lilly for those comments. Received a comment letter from Margaret Towser, who's I hope I'm pronouncing her name correctly, a retired scientist with NIMS, directed to the bypass flow issue, and then a letter from several signatories from the Karuk tribe and the NGOs that were part of this proceeding, discussing bypass flows, recommending a limitation on the diversion to 0.5 CFS in the summer, requiring that the diversion be piped instead of using the earthen diversion ditch, and then a request that water be shared for fire suppression purposes. Spent a fair amount of time talking about the bypass flows, so I don't want to get further into that unless there are questions. But with respect to the limitation on diversions to 0.5 CFS in the summer, we don't have enough evidence in the record to support that kind of limitation. And then on the sharing of water for fire suppression purposes, a similar issue, not enough evidence to require that. There would potentially be a takings problem under the Fifth Amendment of the Constitution with requiring a private water right holder to share water with other private persons without compensation. And then finally, the evidence in the record does suggest that when there are fire suppression activities going on and water from Stanshaw Creek is being used for that purpose, that it's actually the firefighting agencies who are making the call about taking water out of the system and where it should be applied. Mr. Albers and his colleagues also made an attempt to distinguish the El Dorado case regarding the rule of priority on the bypass flow issue. I want to just touch on that briefly. The way they attempted to distinguish that case was by saying, well, in the El Dorado case, the senior user was curtailed entirely, and here the bypass flow wouldn't necessarily entirely curtail Marble Mountain Ranch's diversions, so there's a distinction there. I think that's a distinction without a difference. I think under the general rule of priority in the El Dorado case, any sort of curtailment of a senior user before a junior user is going to be problematic. And there are exceptions and ways to get around that rule, and those are sort of laid out in the order. But in general, that's at least our understanding of how the rule of priority works. And then finally, we received a number of comments from Mr. Conrad Fisher, who was a party in this proceeding. I mean, he's been fairly zealous in making sure that I receive those comments in terms of emails, and I appreciate that zeal. I want to just be clear for the record that unfortunately I'm not able to respond to those directly due to our ex parte rules, but we certainly received those comments. Mr. Fisher would like to see the order modified to prohibit the diversion of water that doesn't get put to beneficial use, which I think the order effectively does by requiring a diversion control device and insisting that water that's not consumptively used be returned to Stanshot Creek. He and both Marble Mountain Ranch have suggested that it's not technically feasible to install a diversion control device at the point of diversion for a variety of reasons, and suggest that the proposed order require that well, Mr. Fisher suggests this, Marble Mountain Ranch does not. Mr. Fisher suggests that the order require that that the diversion be piped and a further diversion control mechanism be installed at the place of use. The approach of this proposed order is not to be prescriptive about what's required. That may ultimately be a pipe. A pipe can certainly be a type of diversion control mechanism. There may be other ways around that. The order does, as currently written, require the respondents to develop a compliance plan and submit it to the enforcement team. And if there's any disagreements between the enforcement division and the respondents, those disagreements can be resolved by the deputy director for the Division of Water Rights. I think there's sufficient flexibility with that compliance plan to allow for a variety of methods of controlling the diversion. But we're suggesting that we not be prescriptive in terms of what those methods are. Mr. Fisher has also suggested, like the other some of the other commenters, that the order require that water be shared for fire protection. I think we've already addressed that, so we'll move on. The respondents had two principal comments. One is that the order is moot because there have been so many changes in the system since the case was heard in 2017. And there have been a number of changes, and one of the most significant ones, and this is detailed in the order, is that the respondents have installed a solar system that will help obviate the need for large hydropower diversions, and they're to, I guess, be commended on making that change. But the order, there are two issues with this mootness argument. One is that they had a chance to tell us that we needed to reopen the evidentiary record to deal with this issue, and they said no, get an order out, just like every other party did. And the other issue is that the hearing issues and the charging document and the hearing itself were aimed both at future potential unreasonable use and also identifying past methods of unreasonable use and diversion. So the order certainly is not moot from my perspective. We had a number of comments on the bypass flow issue. I've talked a little bit about some of the problems with the bypass flow recommendation. A number of commenters raised the issue of water quality and how bypass flows can support water quality issues there. That's something that can certainly be addressed through the compliance plan process and also by the other agencies who participated in this proceeding who have regulatory authority to require Marble Mountain Ranch to change its operation in other ways. I'm thinking of Fish and Game 1600, et cetera. There's going to be a number of permits that are needed to comply with this order, and those provide avenues for resolving some of these concerns. And then finally, I'll just mention, Water Climate Trust brought up the issue of quantifying what the scope of their right is, and also raised some comments about water quality impacts related to an access road near the point of diversion and the diversion ditch. And again, the issue of fully quantifying the scope of this right just isn't before you. It wasn't an issue for the hearing And then in the access road, I just think there's insufficient evidence in the record to make any particular findings about the impacts on water quality. And I will again highlight that there are other agencies with regulatory authority to address that issue, including the regional board order that is in effect for this diversion. So next slide, please. And with that, that'll conclude my presentation, and I'm happy to answer any questions you may have.